Senator Batters.
Thanks very much. Many questions today, Minister, on such a wide-ranging number of provisions, especially from you on this bill. I guess I would start with, we have one of the things that we haven't even heard from witnesses about, I think we'll hear from them later today, is about this Division 3 Subdivision B about digital assets, including virtual currency. So this part of your government's 430-page Budget Implementation Act will expressly allow for searching for digital assets with a computer program, plus allows for seizure, detention, and return of those assets. It also allows you, as the Attorney General, to ask for tax information from the Canada Revenue Agency for a list of crimes. Now, given what we saw last year in Ottawa with the trucker convoy and how things proceeded, with a lot of controversy on that, why have such a wide-ranging, not only this part, but then we have these parts, that with regard to the Canada Post thing about the shipping potentially for fentanyl dealers. We have the criminal interest rate things. These are generally things that I think it would be much better if we could look at these types of things in a substantially elongated method of studying these at the legal committee, rather than just simply really a very short time frame to study and minimal a chance to amend in a Budget Implementation Act. Why do these kinds of things in that, specifically about the digital assets issue?
Well, this is a bill brought forward by the Minister of Finance, so maybe with respect to inclusion, they are financial matters. They're important financial matters, but that particular part of the question is probably better directed at her. What I can say is that these kinds of powers were called for explicitly in the Cullen Commission report out of British Columbia, which studied money laundering very carefully. And so the increased access to tax information, the new seizure the new seizure power for digital assets, again, something that we want to give our law enforcement agencies the tools that they need while balancing that against the rights of individuals. The other thing I would add is this is very different from the Emergencies Act. The kinds of powers that were given during the emergencies or reused during the Emergencies Act with respect to cryptocurrencies or digital assets. Those were temporary measures that were meant to be temporary. Here, you have to go to a judge. You need prior authorization from a judge for a warrant, which is a very standard safety valve mechanism that we use with warrants in our criminal justice system. And it's worked well, and I think there's no reason to think it won't work well here.
Well, we'll see when we have some more information. It's difficult to have a full way to study it and assess it without that. But let me go on to another area here. Yesterday, we heard about this, the Canada Post issue, and police that we heard from yesterday have said that criminals exploit an antiquated legal loophole which bars them from searching packages sent through Canada Post, but that limitation does not exist for private courier services like FedEx and UPS and even Purolator that's owned by Canada Post. So the Canadian Association of Chiefs of Police passed a resolution in 2015 about this, and the Canadian Civil Liberties Association said in 2019 it's time to close this loophole, yet the government is only addressing the issue now in 2023 and just in part. Maintaining the restriction on letters will certainly preserve Canada Post as potentially the preferred shipping method for criminals. Private courier companies don't have this restriction on letters. So we heard from Michael Rowe from the Canadian Association of Chiefs of Police, quote, including the ability in all amendments moving forward for police or postal inspectors to be able to search both packages and letters would have a significant impact on community safety across Canada and the ability of law enforcement, both postal inspectors and police, to be able to investigate crimes where Canada Post is being used to traffic contraband, unquote. So, Minister, does it concern you that with the exclusion of letters that you've allowed for here, rather than continuing or including the type of measures that the private members bill from Senator Delphine puts forward, does it concern you with that exclusion on letters, a Crown Corporation will remain the shipping method of choice for fentanyl dealers?
Well, we certainly have addressed in this case the response don't want to say the fallout, the response to the Gorman decision in Newfoundland. So there is a uniform standard now for the search of packages that come through Canada Post, and they can be looked at. It's charter compliant. Again, reasonable grounds to suspect, which is again a standard that is well known to law. With respect to mail, that's a larger question. I agree with you, Senator, that that's an important question, and I'm open to looking at that moving forward. But I do agree it hasn't been dealt with here. That's true. I know that, as we've said, there is a private member's bill, from one of your colleagues that proposes to look at that. But it is something that I'm open to looking at.
Sure. Why not just include it, though, now? If you're going to proceed in this way, why not just include that particular part?
Well, it's a larger issue, as you have rightly stated in the framing of your remarks. It's important not only to law enforcement, but it's also important to the protection of human rights to privacy under the Charter. It's a little trickier, I think, than a package, and so it needs more work.
Minister, on criminal interest rates, going back to that, banks can provide bridging financing, like bridge mortgages, which are short-term loans that can help people purchase a home, but could have rates that could exceed your new criminal interest rate under this act. So, Minister, when I asked the Department of Finance officials about that, Mr. Radley confirmed that bridge loans could be considered for an exemption under the upcoming regulations. So I find it very concerning that we're being asked to pass this change in a Budget Implementation Act, which will no doubt be passed within a few weeks, as is normally the case, and then yet a very significant number of bridge mortgages could be impacted, and we won't know whether they will be getting an exemption to this new criminal code provision until after the budget implementation bill is passed, when Cabinet makes a decision then. So why wouldn't this section, which deals with a very important issue, be tabled as a separate government bill so that the necessary Senate committees and parliamentary committees have time to study it properly and make any necessary amendments?
Thank you, Senator. I think I've answered the last part of the question, which is why not a separate bill. I certainly share the concern about how much goes into a budget implementation bill. That being said, that was not my decision, and I have to trust my colleagues in that regard, and I do. The particular concern you raise is a good one, and the point of the regulatory exemption is precisely to allow those kinds of high-risk transactions where the parties have a certain set of have a certain capacity or knowledge, so they're not vulnerable in any way. You mentioned the bridge financing, perfect example. So my understanding is that regulatory exemption is meant to capture that, and that the regulations will be published. There will be a consultation period that will allow people to comment on the proposed regulations. So that will be subject to the usual kinds of parliamentary scrutiny that we have with respect to regulations.